Yeah, today's panel is state level perspectives on the trial penalty, the price of a trial. And we know that the price of a trial is high. I think the federal system is better understood generally than the state systems because we have such comparatively robust data from the U.S. Sentencing Commission. The statistics are well known. We know that of convictions, 97 to 98% of those are coming from plea bargains. Um, Only 2 to 3% of cases of convictions in the system are a result of are a result of criminal trials. And we know that the numbers are basically similar in state systems. We also know in the federal system that trial sentences are 3 times higher on average than plea bargain sentences, which is a pretty shocking number. We know for some crimes, and in some cases, it's many times higher than that, 8 times, 10 times. And in states, it's similar, although there is a compression due to so many more state cases being misdemeanors. There are very few misdemeanors, of course, in the federal system. I want to discuss this and with my panelists today, and I'll introduce them briefly. Deborah Delpret Sullivan is legal counsel and director in the Connecticut Office of the Chief Public Defender. Professor Lucien Dervan, a professor of law at Belmont University College of Law in Nashville, Tennessee. He's also the founding director of the Plea Bargaining Institute, which works to serve as a conduit between practitioners, policymakers, and academics who are all interested in research on plea bargaining and the trial penalty. And last but not least, Preston Shipp, the chief legal and advocacy officer at Fair and Just Prosecution, also a former prosecutor himself in the Office of the Tennessee Attorney General. Um, so let's get started. We know that I'm going to start with Deborah. Just I'm going to start with the general. I think that's inductive, right? Deductive in general. Um, what is your experience as a public defender with the trial penalty in Connecticut? Connecticut, an interesting state, small state, but large population. It's dense. Just talk about your experience a little bit, Deborah, please.
Well, our experience has been that, we have a really wonderful system here, and in that, we've got a wonderful public defender system with over 400, almost 500 employees here. It's a statewide system. We just celebrated our 50th anniversary and had a wonderful dinner last night about that. So we're lucky to have a robust defense system here in the state and have assigned counsel that are able to come in on contract cases where there are conflicts. But the issue is that more than the majority of our cases are handled by way of a plea bargain. And back in 2014, 2015, the reason I got involved and interested in this was we were looking at those cases from the Supreme Court, Miller and Graham, where they were talking about second looks for juveniles. And I remember meeting with a young woman who was a sister of one of the defendants and her mom. And they were there in the ladies' room at the Capitol here in Connecticut, and they were in tears because they wanted their son or sister or brother to have, a second look at the sentence where he had been charged with felony murder and he had been given this, crazy number for, a plea bargain. Since he was not the person who actually had, pulled the trigger in that particular case, he was surprised that he was being charged as someone in the felony murder with the same type of, penalty or maximum exposure. So we chatted about it, and he went to trial, and he ended up with like 20 more years than he would have gotten if he had pled out. And so they were there on behalf of him speaking. Years later, our Racial Justice and Cultural Competency Committee of the Office of Chief Public Defender here in Connecticut had as a legislative suggestion, could we take a look at the trial penalty that's happening in the state? So we developed a survey to send out to everyone, because what we were getting back was feedback that if you wanted to go to trial, you really were going to be penalized, and not with, a couple of years, but double digits, and not always, 10 years. It could be more than 10 years. And so there was this increase, and it looked like they were trying to deter people or punish people by exercising their constitutional right to trial. So we put together a survey to address that and look at the issues that came about, which is when we ended up getting involved with the NACDL.
Thanks, Deborah. I think let's talk a little bit more about the report a little bit later, but I'm going to jump to Preston now. A lot of folks think that prosecutors have the most power in the system. I think there's certainly as mandatory minimum sentencing has proliferated, there's definitely a shift of power from judges to prosecutors as judges' hands are a little more tied due to mandatory minimums and sentencing. But Preston, what can prosecutors do to, if they're so inclined, to mitigate the trial penalty? And what can we do to get more prosecutors to believe that they should?
Yeah, well, thank you so much, Nate. And I think those people are right. I think prosecutors are the most powerful actors in the criminal justice system. These pleas that are taking place are largely rubber stamped by judges. The heavy lifting is done by prosecutors. So I think that they're exactly right in looking to the prosecutorial community to own and lead on some of these reforms. I'll start, and of course, I work for Fair and Just Prosecution, and that's a national network of prosecutors who and it's diverse, but they're all somehow reform minded. But I'll start by saying something nice, I think, about the current system, plea bargaining system, because it does have some benefits. It is efficient. It saves the cost of litigation and judicial resources. It provides certainty. It provides a mechanism to incentivize folks to cooperate or accept responsibility. But all of those things do come at a cost. And when we talk to our network and encourage our network of prosecutors to pay attention to this stuff, we try to locate these issues within the larger historical criminal justice context, which we all know, but I think it's just helpful to point out this isn't happening in a vacuum, that in the 1970s and 80s, we just pumped trillions of dollars into policing and expanded criminal codes. We started criminalizing things that probably should not be criminalized, and we embraced these draconian sentencing schemes. And so the number of people getting swept into the system balloons by 5 or 600%. And so we went from 15 to 20% of people who were exercising their right to a trial by jury. And that, was cut way down because if people continued to do that, the system would just collapse under its own weight. And so we saw a massive increase in prosecutors applying whatever pressure they could to convince folks to give up their right to a jury trial. And sometimes it was way too coercive. It was charging multiple offenses for the same conduct and threatening these enhanced penalties. You mentioned mandatory minimums, requiring folks to respond to plea offers before they even had a chance to review the discovery, threatening or requesting pretrial detention for folks who decline plea offers, all of which cuts against, I think what we would have in mind when we talk about a justice system. And so, and not to mention, when you give up those rights, you have certain police and government misconduct going unchecked because there's never an opportunity to have it looked at by a judge. So, with all the power that prosecutors have, what we really encourage our network members to do, I've got a list of things. I'm happy to share my notes. But when we talk about this stuff with our network and encourage them to adopt policy reform in their jurisdictions, we start by saying you need to make fair, just plea offers based on what you believe is an appropriate disposition based on the facts and the law. You don't pile on. You don't think about trying to discourage somebody from going to trial. You certainly don't require somebody to plead guilty before they've reviewed discovery materials. You don't threaten to revoke an offer if it's not accepted by a certain time, because that offer should represent what you believe is an appropriate outcome. And so you hold it open. We had one network member who the person did not plead guilty. They went to trial. It was a long trial. After the full first day of trial, the person at the end of the day conferred with their attorney, and on the start of the second morning of trial said, "Hey, I might should have pled guilty." and and the person got the initial plea offer because that plea offer was still on the table, because that was still an appropriate disposition. So not threatening or seeking sentences at trial that are substantially longer. We encourage folks to eliminate any trial penalty altogether, but at least cap the difference, so that if you're talking about, an initial plea versus, what you seek at trial, never more than 15% increase, to keep it reasonable. Um, there's other reforms. It sort of dovetails into other reforms. We don't want to use the threat of pretrial incarceration, which dovetails into another one of our issues for our network, which is bail reform and ending unnecessary detention. We also don't want to see folks being made to waive their right to counsel, their effective assistance of counsel, their right to appeal and challenge sentencing errors, and all those sorts of things. We don't want people to give up more than their right to a trial when they plead guilty. And then something else I just want to mention here is being aware of racial disparities when you're talking about charging decisions and plea offers. We recently had a network member who, in an internal memo, said she wanted her prosecutors to be mindful of racial disparities when they're making charging decisions and plea offers. Not that race should be outcome determinative, but it's just something, if I made an offer last week to a white person, I want to bear that in mind when I've got a similar situation and a person who is black this week. The problem is that may get you investigated by the Department of Justice these days. But it's doing the right thing. We want to document every plea offer. We want to enable long-term data collection. We want to be able to observe trends so that we can continue to work with our plea process. We want to funnel cases into diversionary programs. That's another important issue for FJP is we want to shrink the carceral system. We want to be pushing people in more restorative directions. So I know that was a lot. Again, I'm happy to delve more into those, but I did want to share a quote from one of our prominent network members, who is Philadelphia DA Larry Krasner, and he made a public statement a couple of years ago about his own policies. He says, "We are not going to overcharge. We are not going to try to coerce defendants. We are going to proceed on charges that are supported by the facts of the case, period. The era of trying to get away with the highest charge, regardless of the facts, is over." And so my hope is that FJP and all of the folks watching can encourage prosecutors to see themselves as problem solvers. And when you settle for a transaction, an offer and an acceptance to try to, avoid a trial, you're really neglecting seeing crime within its proper context. It creates needs and obligations that prosecutors need to be trying to address. And so I think hopefully that is how prosecutors can sort of start to see themselves as change agents and not just defenders of this system, which is just riddled with problems.
Thank you. Stepping outside briefly of our, practitioner mindset, I'm going to go to Lucian, for an academic viewpoint. I think Preston touched on this briefly, but if you can jump into a little bit of the history of plea bargaining, I think we have a system that wasn't necessarily always intended to be like this. Doesn't need to be like this, certainly, a lot of us believe. Lucian, if you can expand on that a little bit. Thank you.
Yeah, thanks, Nate. Very happy to be here. Yeah, as Preston was alluding to, this is certainly not the system we started with, and I would argue not the system that the founders intended. It's also not a system that's consistent with the common law. So if you were to go back and look at the English common law about this idea of plea bargaining, you would find that the case law was pretty clear a couple hundred years ago that the kind of incentives that we see being offered in return for pleas of guilt were not permissible in the common law system. And so some really interesting case law, if you look at it back in the 1800s and 17 and 1800s from England, very clearly saying you cannot offer an incentive that would induce a defendant to plead guilty and to give up their right to trial. And it's important to note that that common law came over to the United States at the founding period. And in fact, we have case law, in the founding period indicating that we had adopted a similar tact and approach to this issue. In fact, as late as the late 1800s, there's some very powerful state appellate court decisions talking about the idea of what we would now describe as plea bargaining. And one of the most powerful statements was from a state Supreme Court who said, to them, this looked like a direct sale of justice. And so, I think the thing that's really important to remember historically is that our system is a system of trials. That's how it was founded. Now, I know the reality today is that the trial is disappearing. But I think, we've gotten to a place where plea bargaining is so dominant that particularly people who are just coming into the system may believe that it's always been like this. At the federal system, we're somewhere near 98% of convictions being the result of a plea of guilt. And of course, that is very distinct from where this all began. Preston kind of alluded to some of this, but I'll just talk for a couple more minutes about the historical evolution of plea bargaining. We did see a little bit of what we might describe as plea bargaining today in the late 17 and early 1800s in New England, predominantly in liquor law prosecutions. So not across the board, but just in a handful of cases. One of the interesting things, though, is there's actually a documented case of a prosecutor using plea bargaining in New England in this time period, who themselves were prosecuted for doing this. So that just to kind of give you another sense for how the common law and the law generally perceived the idea of offering benefits for pleas of guilt. It just simply wasn't the way that the law was being applied. But we did begin to sort of see plea bargaining rise in the trenches, particularly after the U.S. Civil War. And again, that's when we started to see some of those state appellate courts looking at these issues saying, no, we're not going to go down that road. But, there then becomes this sort of divergence, which is despite the fact that the appellate courts and the common law had very clearly for some time been saying, we're not going to do this, the actual cases in the trenches began to see more and more plea bargaining. And one of the reasons for that was overcriminalization, particularly in the early 1900s. You really see a spike in what we might describe as plea bargaining around the time of Prohibition. Because of the time of Prohibition, obviously, Prohibition itself brings a lot more cases into the system, and the system becomes overwhelmed. But also, we saw a lot of other criminal sanctions being imposed at that point as well. As Preston noted, the 1900s is an era where the number of statutes, the number of charges, the number of people in the system just grows exponentially. And the response to this begins to be sort of a fresh look at plea bargaining. And so by the time we get to the 1970s or late 1960s, I guess I'd say, people are starting to think that maybe plea bargaining is an answer to what is really an overwhelmed criminal docket. It's at that point that the ABA starts talking about this as an idea to maybe move things forward, create more efficiency. It's also, remember, at the end of the due process revolution, so trials are just taking longer in any case. In some studies, they found that trials sort of doubled in length between the beginning and the end of the 1960s. And that leads us right to 1970 and the Brady decision. And a lot of people, in 1970 would have said the Brady court is going to follow precedent and they're going to strike down plea bargaining as unconstitutional. But that, of course, is not what they did. Instead, they embraced plea bargaining. And I think there's some really important limitations, frankly, in the Brady case that we may or may not get to talk about today. But as an overarching sort of takeaway from the case, they said, yeah, we are going to allow this idea of plea bargaining. And one of the reasons they did is because they wanted to reserve resources for trials. And it's really interesting to see what then transpires, which, as Preston noted, is to move, from a system where there still were a fair number of trials to a system where there just very, very few. When I served on the ABA plea bargaining task force, which released our 14 principles report a couple of years ago now, we were able to identify at least one jurisdiction where there had been several years with 0 trials, which really, from a historical perspective, is shocking. Not only is it contrary to what the founders intended, but it also is not good for the system because the jury is one of the most important methods by which citizens get to participate in our criminal system. And it is a check on the system, and it's part of that checks and balances system. And I just think that we give up a lot when we don't allow citizens to be in that room and to engage in that trial and jury process. So obviously lots of consequences, lots of costs to plea bargaining. But from a historical perspective, I think that's one to note.
Thanks, Lucian. And just to clarify, the case you're talking about is Brady v. United States.
Not Brady v. Maryland, that's
Right,
right.
not Brady v. Maryland, the well-known case about exculpatory evidence, of
We've
course.
got 2 big Brady cases around the same
Yes,
time. Yeah.
exactly. I feel like that's a common source
This is
of
my Brady case, the one that signed off on plea bargaining. Yeah.
exactly. Okay. I want to do a round of questions about research and data. Like I said, the federal system is relatively well understood, although it certainly could be better understood. And we've actually met with the Sentencing Commission urging them to improve their research and data collection on plea bargaining specifically. In the states, it really runs the gamut. It's often the data is not very good. Some states have pretty good data. Some states have almost no data at all. Some states don't even know what percentage of their cases dismiss versus try versus are acquitted versus convicted. There's really almost no data. I want to go to Deborah first. She's one of the few people in the country who's working to actually improve the system and increase our data and research understanding in the state system. Like she mentioned earlier, she's worked for the last few years with NACDL with me on a trial penalty report in Connecticut. Deborah, if you want to go ahead and your office has as well, I should say. But you've led the charge. If you can talk about that report a little bit, how it started, what we came up with, that'd be great.
Sure. So we have a system, besides the paper system, of course, we have a system called Justware that we have encouraged all our attorneys to put their information in, and we want to collect all that information about plea bargains and the charges and the best, the last best plea bargain, et cetera, and how things are disposed of. What we decided to do for a period of time from July 1, 2015 until June 30th of 2020, just before COVID, right during COVID, is collect data. So we went through our system to get all this information. We also we're within the judicial branch of government, although we're autonomous. We asked the court system, to give us as much information they had as far as how many trials had actually occurred during that time period. So they were working with us and gave us a number of cases. And for that time period, what we came up with was 704 cases statewide in Connecticut. But we had a lot of issues because with the survey that we put out there, many of these cases, a huge number of these cases came back as being ineligible because it was either that we had insufficient information given to us, they didn't have the last best offer, or things were vague and we were trying to get as much information as we could. And then also we recruited, the help of all our public defenders, our assigned counsel, which are the conflict counsel under contract, and then the private bar. Some people decided, not to participate. It wasn't a mandatory type of thing. So there are cases that were given out there, surveys given out there, and people, who responded. It was great. But again, that information had some, inadequacies. So what happened out of the 704 cases, only 164 cases were found to be eligible. It's a very small group of data. But we went through what they call the IMRP. It's out of UConn, University of Connecticut, who helped us with an analysis of those cases. And they looked to see where, based on what we had, what the issues were that we could at least identify. So we decided to look at all this information. We drafted up our own survey with the help of individuals here at the Office of Chief Public Defender and sent that out. Spoke to Nate in the meantime, and I think this was after the New York report had gotten out. And we were very interested in that based on the feedback that we were getting, with some of the things that Preston was talking about with the upcharging and worrying about stacking of charges and things like that, on the eve of trial. Or in our state, since we are a state that has sequestered, individual voir dire, many of our clients will get very intimidated, going through the voir dire process. And unless there's a motion that's dispositive, many of the motions are held up until the time of trial, which could be 2 or 3 years after the charge. So, people are incarcerated during that time. They get intimidated by the process, and then they get this offer, and then they decide to plead out. So at any rate, we started to look at all of this. And it was really interesting to see the information that came out of the IMRP. They're also very valuable. They do our racial profiling data and our reports on that as well. And we ended up finding out that there was overall, based on the data we have, 62% of the convictions had a trial penalty. And it ranged, it was all over the place because we looked at misdemeanors as well as our A and B, the most serious of our felonies here in the state, onto C, D, and E felonies as well. And it definitely does exist. And they looked at the demographic information as well between Black and Hispanics versus white. And definitely, again, there was that disparity, and there was that definitely there was the issue that came up with these types of cases. And they also looked at gender. So we have put together this information in a report that will be out soon. And then from there, we have also, I can talk about after, the recommendations, some of the things that we know we have to do. Data collection is the most important piece of this. And, I wish we had all those other cases that we could have really taken a look at it. But what we did see did give support to what people were reporting from the field. And that's what's so important to see.
Agreed. Thank you. Let me go to Preston now. I think a lot of folks, I think the judiciary is probably the best source, and this is what the federal system does, obviously, for sentencing data. But plea offer data is only available usually from the lawyers, from defenders, and from prosecutors. Is that something that, you work with the folks you work with, Preston, with prosecutors to try to collect, or do you try to encourage prosecutors to improve their own data collection efforts? I know there have been certain offices around the country that have done highly publicized or somewhat publicized efforts on that. What are you doing? What can you do?
Yeah, that's something that's really important to us. I think, as reformers, the more information that we have, the better off we are. Because if you don't know what's happening and you don't know what your line prosecutors are doing as our electeds, it's hard to improve upon something that you don't really have a good handle on. So we have usually about four convenings a year of our network, and we have really an entire department that is sort of given over to data and policy, and so they will sort of coach folks in our network about not reinventing the wheel. How to manage your data, how to keep up with plea offers, whether they're accepted or rejected, so that you have a record going forward of what kind of offers you're making and when in the process this is happening. And we want really for them to get as full a picture as they can about how the plea process is working in their jurisdiction. And in addition to those convenings, we also do site visits, especially when we're talking about a prosecutor. There's a big difference in Larry Krasner in Philadelphia and somebody who's in a small town, in Mississippi or something, in terms of their resources. And so, especially for our prosecutors who are in smaller jurisdictions, we'll do site visits where we'll have FJP staff to go and talk to them about how to build out a data collection process that doesn't break the bank, best practices for making sure that you understand when these offers are being made, and what the nature of the offer is, the percentage of offers that are being accepted, how many cases are going to trial, what the disparity is between what the offer was and what the trial outcome was. Again, as I mentioned in my initial remarks, I think that having that information at your fingertips is so important for establishing trends. If a prosecutor comes along in November of 2025 and starts this data collection process, then by November of 2027, they should have a good handle on what needs to improve in their office. And so we really stress that, and we want to provide institutional support for prosecutors who are trying to do that. Just again, that's how we get things. We start to correct where things have gone wrong.
Good. I'll go to Lucian. Academic research on plea bargaining. I know there's so many different fields. You're a law professor, but I know you've worked with, criminologists, psychologists. There's all sorts of academic research on plea bargaining. If you could touch on a couple of the interesting things that you or academics generally have found.
Yeah, happy to do that. So, first, just to kind of, as Nate was saying, we've really seen a broadening of the disciplines who are examining the plea bargaining system. A lot of work in the psychology field, criminology, obviously. We've got some economics work now happening in the space. And of course, the field of law has always been very interested in plea bargaining, or at least for the last couple of decades. I would encourage people, if you want to kind of have an opportunity to peruse the vast amount of research that's out there and think about ways that it might affect your practice, your policy work, take a look at the Plea Bargaining Institute website. One of the things we're really proud about is that we have worked to make academic research more accessible to people so that they can use it in their motions practice, they can use it in their litigation and in their advocacy, generally speaking, and policy work. And so if you go on the Plea Bargaining Institute website, we have what are called the summaries. And if you click on the summaries, you can review the material we put up there. We have 59 Supreme Court cases regarding plea bargaining summarized there for your review. We also have north of 130, and the number is growing pretty quickly, summaries of academic research and data that may be very helpful to you. And we've got keywords you can use. You can search for the keywords in our summaries as well if you like. I think a great resource for you to kind of see the things that are out there. And I'll just say, one of the reasons that I created the Plea Bargaining Institute is because, having been a practitioner, I kind of floated back and forth between the academic world and the practitioner world. And I would often hear a disconnect between the two, whether that be academics who were looking for things that they wanted to do research on but weren't sure sort of what would be helpful to the bar, or members of the bar who would talk about litigation motions that they had where they were looking for some support, some research, some data to back up their arguments and couldn't find it. And the Plea Bargaining Institute is trying to sort of bridge that gap by making that stuff more accessible to you. I'll just sort of, Nate, to your general question about where the research is, obviously lots of different spaces that we're in. One of the spaces that I do a lot of my research in is plea bargaining and innocence. So I'll take the opportunity to just chat for a minute about that. We know that innocent people falsely plead guilty. One of the challenges has been to get a sense for how broad this is and what are the forces that are contributing to this phenomenon. If you look at some of the data that comes out of the Innocence Project, for example, and the National Exonerations Database, really interesting because we're seeing a very significant growth in the number of exonerations that involve pleas of guilt. A lot of reasons for that, obviously, but I think it's a really important testament to the fact that we're looking at this stuff more closely than we did. We used to really focus on trials with regards to this kind of issue, and I think we've come to the place where we realize there's a significant number of innocent people who have pled guilty, not just been convicted at trial. And so it's really encouraging to see those types of networks doing that innocence work, really focusing in on cases that involve pleas as well as cases that involve trials. If you look at that data, one of the really interesting data points recently is the growth in what are called no crime exonerations, which are people who are pleading guilty in situations where there actually was no crime in the first place. Sort of the whole system failed and ended up leading to a false plea by an individual, not only in the sense that it wasn't the right person, but there was no person. There was no actual crime that had ever happened. The whole thing was a collapse of what the system is supposed to do, which is to figure out what's happened, figure out the facts, and find a just resolution. So I'll just mention two studies that I've done on this issue. The first we did a little over 10 years ago now, I guess. And it was the first study that really looked in a laboratory setting to identify the phenomenon of false pleas of guilt. So we took individuals, we falsely accused them of academic misconduct. They truly believed that they were being accused of this in the academic setting. And then we offered them a deal to see what they would do. And we had two buckets of participants. Half of them had actually engaged in misconduct. We had sort of set it up that way. And the other half had not. And they definitively knew they hadn't, which I think is really, really important in a world of overcriminalization where a lot of the statutes aren't really even clear. But in this setting, it was very clear whether it happened or not. 89% of the guilties took the deal and pled guilty. 56% of the innocents also took the deal and falsely pled guilty. So it's just an indication of how broad this problem is. And it's also a confirmation of what we knew from a psychological perspective, which is that this is what people do. They make decisions that are rational. They engage in temporal discounting, where they want a benefit today rather than a potential benefit down the road. All of it makes perfect sense, but it was really important to identify this in a laboratory setting to show that this is what's happening from a psychological and decision-making perspective. The other study I'll just mention is that a few years after that, we began another research study that actually was done in the US, Japan, and South Korea simultaneously. And I'll just talk about the US data for a moment. And that is in part because of what was happening in Japan, where they were introducing kind of a unique system of plea bargaining that required an individual to testify against somebody else to get the benefits of a bargain, which meant it wasn't available for individuals alone, only in cases of group criminality where there was somebody else to testify against. And Japan had done this because they thought this would address perhaps the innocence problem we had previously identified. So we ran the study, but one of the differences was, in addition to pleading guilty yourself, you had to agree to then testify at a formal hearing or trial against a co-defendant. And we had very similar numbers with regards to false pleas of guilt, 66%, so actually a little higher, in fact, than we had even seen in our previous study. But the thing that I wanted to share with you was that of the 66% of individuals willing to falsely plead guilty in this study, 88% were willing to falsely testify at trial against a co-defendant. And I think one of the kind of big takeaways there is this is how the system, sort of the innocence issue, perpetuates itself. So you have one individual who falsely pleads guilty, then agrees to testify falsely against somebody else. That is going to probably incentivize that person to falsely plead guilty as well. And you see these cases, like the case in Beatrice, Nebraska, where you had multiple defendants all pleading guilty to a gruesome homicide, and not a single one of those people had anything to do with it. And this is exactly why that happened. So again, to the issue of costs of plea bargaining, Yeah, there are the benefits of efficiency and encouraging cooperation and acceptance of responsibility and beginning people on the road to rehabilitation, et cetera. All very important, but we also have to be very aware and really focused on the costs of plea bargaining, particularly where you have those large sentencing differentials. And of course, the large sentencing differential, one of the main drivers of the innocence issue. Not the only driver, but certainly one of the main drivers. So.
That's fascinating and shocking. Can I ask for a quick clarification on situations where no crime actually occurred? I'm thinking of cases like shaken baby syndrome, where the science has really been questioned, and
Mhm.
if people there's actually no abuse and there was a medical condition, or something like an arson case where someone is accused of arson, but it was actually accidental. Are there other types of cases out there in this like no actual crime sort of
Yeah.
bucket?
Well, I think those are the kinds of
Yeah,
cases, right? Where there's a perception that there may have been a crime. There's a false plea which validates the perception that there may have been a crime, but then it all sort of unravels when people realize, you know what, that didn't happen here. This person didn't commit a crime. There actually wasn't a crime. This was an accident, as you described. I don't know the breadth with which the national database on exonerations defines the term precisely. But I would encourage people to take a look at their annual reports, in which the last couple have talked about this issue and identified the cases. And you can see some, I guess, further examples in there of the types of things that would be identified there. So,
got it. Thanks. Let's shift gears a little bit again, and we'll talk about policy solutions. I know a bunch of folks in this attending this conference often are policy advocates or lawyers in their own states. Let's talk about solutions and policy, solutions for the trial penalty. I think a lot of the times I focus on policies that are bad. There's mandatory minimums, and prosecutors are allowed to do X, and the law doesn't allow judges to do Y. But I want to go to Deborah, who kind of mentioned this in her own comments. And she said there's some, I think a lot of states are doing things well, and I invite her to, mention a few things that she thinks her state does well in trying to limit trial penalty sentencing, or things that, based on the report we've done, the work we've done, to do better.
Well, in our state, we're really lucky. I mean, we have great access to all of the different task forces. I'm the legislative liaison for the agency. So in the last, number of years that I've been in this position, I mean, we really have been able to be at the table for all these conversations. We have a wonderful relationship with the co-chairs of the Judiciary Committee and the members of that committee, the Appropriations Committee. So being a state agency totally funded by our legislature, we are very, very honored and able to be part of that discussion, have work with other stakeholders, work with other state agencies in trying to come up with solutions, whether it's like creating more diversionary programs, having more things, at the court system where we could have, with probation, working with them. We have a parole revocation unit, creating our own units within our agency that would help in some of these other types of situations. And we have an innocence project here in the state of Connecticut as well, in addition to our post-conviction appellate and habeas. So we're very lucky in that regard. We have resources to deal with this. We have great resources for experts and for others for our assigned counsel as well. But, there's other things that we would like to have eliminated. And so we've got that access to those individuals at the legislature, like to talk about mandatory minimums, which many of our members of the legislature would like to do away with. The three strikes is we have what we call the persistent offender statutes. We've talked about that. We see that as hurting people. And we've gotten a lot of support in having more look back statutes, like in our DUI, looking back 10 years ago. Don't let this be like a second conviction if it's more than 10 years ago. So using the look back features, and also what we call clean slate in this state. So we have wonderful things that are happening as well. It's just that, and we're able to discuss these things with the state's attorney. I want to make that clear that we have meetings with them and work with them as well. It's just that still, when it gets to the time of trial, we do see in certain jurisdictions, and we have 43 offices throughout the state, and we do see where, there will be an offer, and if it's not accepted, and we push to make sure we get all the discovery ahead of time, but if it's not accepted, it goes on that firm jury docket, and we're concerned about where someone's going to give a number and then just say, well, we're going to use a persistent offender statute, or we're going to, do a substitute information and change the charges. And again, we believe in an effort to, of course, to get a plea bargain and to coerce that. So We have a couple of things that we'd like to look at. Bail reform is one of them. That's been a hot issue around the states, but we're concerned about how that could also impact on our clients. We've traveled to DC, we've traveled, to look at what's happening in New Jersey, and we've looked at the New Mexico model, and we have a lot of concerns about things that are happening there as well. We'd like to see more reform in the area of nonviolent misdemeanors. And, so we're working with other people on those types of things. And one of the things that was mentioned in your person who won the award was working with survivors of certain offenses when they become our clients. And so we're very active in working with those groups that are looking to have those individuals, where we can present more mitigation on their behalf when they become our clients. So there's the good and the bad, and we have a lot of good here in the state of Connecticut. But how can we control these numbers? And I don't know what the resolution would be. I hear what I believe Preston was talking about. There was a percentage of not letting it go. I think he said 15%. I mean, but how do you control that? If you've got a case 1 week, after the person has spent 2 or 3 years in jail and it's worth this number. And so then you start picking a jury and, 2 weeks later after trial, all of a sudden the number becomes in our study, apparently the number was like 14.6 years is the average trial penalty here. All of a sudden, a couple of weeks later, it's that. Where has the change occurred? So, we're trying to find those types of resolutions, and how can we? Is it a legislative fix? We're not really sure.
Thank you. I'll do a quick reminder on questions. Oh, Shuli's doing the same thing, I think, in the chat. But if there are questions, please go ahead and send them in via the Q&A box on the bottom of your screens, and we'll get to them in a couple minutes here. I'll shift to Preston. I think we agreed earlier that prosecutors are one of the probably the strongest, maybe at least one of the strongest players in the system. If they want to avoid trial penalties, which I think we all agree they should, what is the first thing they should do, or what are some other things? What are some of the other maybe creative things they could do, Preston?
Yeah, I think, and I alluded to some of this in sort
Yeah.
of my opening remarks, but I think, one of the things that I think is so important is leaving offers on the table. I think the only reason for revoking an offer is because you're trying to pressure someone into waiving their right to a trial by jury. And I, as a former prosecutor myself, I get it. I get that there are just some very practical considerations. As Lucian was talking about, we can't try all these cases. We've got to provide a mechanism for folks not standing on their right to a jury trial. But I think making sure that you leave those plea offers open, and that it is based on the facts and the law. If we do the data collection and we're not just sticking a plea offer on a slip of paper that makes its way into the file that nobody ever really sees after the file is closed. If we're doing our data collection and we see a vast disparity between cases that are pled, and similar facts, similar code violations, and you're seeing the kind of disparity that Deb was talking about, at that point, that you've got a problem, that you are more than likely, whether it's inadvertent or intentional, you are creating a coercive process that you are. It's not necessarily based on the facts and the law. It's based on what we think we can get and how we want to discourage people to waive their constitutional rights. So I think one of the first things that we really encourage folks to do, because sometimes it's baby steps, for our network members. You can't get them to do everything all at once, but you say you've got to keep track of what your line prosecutors are offering, how often it's being accepted, and then what happens with the disposition if they go to trial. And get that percentage down. And one of the best ways to do that is keeping those offers open, so that after they see their discovery and they have a better sense of what they're up against, they still have the opportunity to kind of take the exit ramp away from their trial. And even after the jury is impaneled and opening statements are made, not foreclosing on the opportunity to say, what, this was a bad idea. So keep those offers open. I think that's one of the most important first steps that we encourage folks in our network to take.
I think that makes a lot of sense. It handles a couple of different, kind of common coercive tactics we see, like exploding offers where it's like high pressure, decide in 24 hours or 48 hours. and also having to plea bargain before there's been any discovery to the defendant, right? That's a it's a simple like one step solution that does ameliorate some really coercive possible tactics that some prosecutors may take. Lucian, how about you? What have you seen? I know the PBI has looked at this. There was a PBI conference in the spring. What sort of interesting policy solutions have the academic community or other folks about what have they come up with?
Yeah, well, first, I just wanted to note that thinking about it from an advocacy perspective with regards to legislation, for example, coercive incentives that lead to false pleas of guilty, as an example, are a community safety issue. So some of the research that I've been engaged in most recently looks at serial offenders and is able to identify a number of cases in which a serial offender went undetected in the early days of their offending because the wrong individual was looked at for the case and they were offered a coercive deal and they took it and they falsely pled to something they hadn't done. And it resulted in sort of the investigation moving in the wrong direction and them just not seeing that this was actually a single individual engaged in conduct. So first, I just want to say, there's a lot of different ways to look at the issue of plea bargaining and lots of ways that this is affecting our system. And I think community safety is an important one to remember. As far as policy, legislative efforts, I mean, first off, I think to echo what others have said, I would really encourage people to look at creating legislation in their jurisdictions around data collection. Having good data, understanding what's actually happening, and to be able to use that in our research, but also to communicate that out to the public so people understand what this really looks like, is really important. But in many jurisdictions, we just don't. We just don't know. I mean, it's surprising, but in many jurisdictions, we can't even tell you how many cases are being pled out versus how many go to trial. We just have no idea. Even that level of data is not being maintained, let alone information about what sort of the trial penalty might look like there. So I do think data collection is one of those spaces where there can be a lot of work done at the state level through legislation and done very effectively as well. Just to echo again what Nate was saying, I'll finish by saying if you look at the NACDL trial penalty report, there's a number of principles and recommendations in there. The ABA 14 Principles report, of course, has a number of recommendations in there as well. And some of them have some complexity to them. But as was said a minute ago, there's also some low-hanging fruit here. There's some stuff that we could do very quickly and very easily that I think would make the system better. Things around discovery and making discovery available to people prior to pleading guilty. Things about exploding plea offers. The differential size obviously is a more complicated question, as Deborah alluded to, but obviously something that we need to be looking at and thinking about. And I'll just finish by saying one of the things we talk about in the 14 Principles is education. And frankly, I just think conversations like this are really important because the more people understand how the plea system actually works, the more people understand how incentives can lead to false pleas and similar costs of plea bargaining, I think the system just begins to look different. And even without specific legislation, without specific things being done, I think that just changes everybody's perspective about the reliability of the system. And, one of my big takeaways from my research over the years is the system is just not as reliable as we thought it was. And a lot of people sort of hang their hat on the idea that, well, maybe I wasn't sure, but the person took the deal. They said they're guilty, so it all worked out. I guess I was right. And the research just shows that's not true. And I think just pausing for a minute to recognize that is a really important starting place.
Yeah, thanks. I'm going to look for questions. I don't see any questions right now. If there are any, type them in real fast. In the meantime, I'll ask for last words from everybody from my panelists. Preston, Deborah, Lucian, any final words while we wait for questions to pop?
Oh,
Sure. I just wanted to say thank you for asking me to be part of this panel. And thank you to Preston and to Lucian. Your comments are really very interesting. And we will be looking to maybe move to meet with you all and discuss this further. But thank you all very much. We're also looking at like the next 5 years from this report. And we're trying to make sure that our data collection has improved. We've done some things to that. And I'm hoping to have, after this report comes out in the next month or so, to continue on and have another report where we've had better data and maybe had some better suggestions to this issue. So thank you again, and thank you, Nate.
I want to echo those thank yous, and also I dropped my email over in the chat. If hopefully everybody can see that, but we definitely fair and just prosecution definitely wants to partner with folks who are looking at these issues, and if there's prosecutors, that would like some of the services and things that we try to provide, network support, be glad to talk about that as well. But yeah, thank you all so much.
Yeah, and thanks everybody. I really enjoyed it, and looking forward to keeping this conversation going.
Yeah, thank you very much, my panelists. This was a very interesting discussion from different perspectives. I will give a quick plug for our, trial penalty reports, our work. The federal report, I think the link was in the chat, as well as the New York report, the only, statewide trial penalty report thus done, which we partnered with our New York State affiliate, NYSACTL, on. Terrific report came out a couple of years ago. Folks know I'm working with, Deborah and I have a report coming out hopefully in the next couple of months, and I'm working on others in a couple other states as well. So be on the lookout for those. And thank you again to our panelists for a terrific discussion today.